morning, everyone. So thanks for joining us today. We'll jump right into the new California Pay Data Reporting Act. And let me give you a little bit of background. I think that a lot of people think like, what is this thing? You know, I don't even know what I'm supposed to do with it. And a lot of people look at it as something that's removed from the realities. And so I wanted to really give it a background so that everyone understands where it's coming from and what to expect from it. So it actually has a really long history, and our governor signed into law just in September Act, Senate Bill 1973, which created this massive pay reporting requirement for employers. And the key thing that we need to remember as employers is that there has been a gender and racial pay gap that's been prevalent over many decades. And so this legislation essentially tries to remedy that. And in essence, there's two main gaps. One is the gender pay gap, and as the name, as the phrase speaks for itself, it's basically a measure of pay differences between men and women across an organization or society, which can be examined in different ways. For instance, median salary versus looking at the mean salary, and is construed typically as a share of $1 earned. To date, I know that there's been a lot of updates to this area of law, but to date, there's not enough data that's been collected concerning pay discrimination involving non-binary gender. So it's a little bit behind its time, as far as the statistics go. The racial pay gap is essentially the same thing, but is a measure of pay differences between racial and ethnic groups across an organization and society. And it's examined exactly in the same way as the gender pay gap. And regrettably, the gender gap is compounded for women of color. And just to give you an idea, the wage gap translates into an annual median loss of over $24,000 for Black women, almost $30,000 for Latinas, and over $24,000 for Native American women, and over $8,000 for Asian women. So it's significant for women of color. The timing of this legislation isn't, it coincides with the impact of COVID-19, and it's definitely exacerbated existing gender and race inequalities. For example, unlike the financial crash of 2008, I think COVID has and will continue to lead to more job losses for women and people of color. And some examples that I have here are, women are almost 2 times more likely to be vulnerable to the impacts of the pandemic than men. And the African American and Hispanic population, and COVID-19 has hit African Americans and Hispanic Americans especially much harder than other populations in the workforce. What we've seen, because I do employment defense, I'm seeing definitely a rise and an explosion of employee claims. And that's, particularly been slow in March and April of 2020, but there has been a significant rise in it since then, towards the end of 2020. And that's mainly because a lot of employees who were laid off, who were furloughed, and some who were rehired at, on different employment terms are finally lawyering up, regrettably. And so there's been a flood of employee claims related to COVID due to furloughs, layoffs, and rehires. And I think that the unique combination of health and safety concerns, as well as different economic realities of these employment actions like furloughs and layoffs, creates a significant risk area for businesses, as I'm sure you all know. And so I think that you need to really watch out for that and make sure that you're getting the legal advice that you need when you undergo a layoff or a furlough. So let's take a quick look at the examples of US law that's already prohibiting pay discrimination on the basis of gender, race, and ethnicity, just to see what we are building on. So the Equal Pay Act of 1963, which only covers gender, requires employers to pay equal wages to men and women performing jobs that require substantially equal skill, effort, and responsibility, and are performed within the same establishment under similar working conditions. The Act provides 4 justifications for gender pay disparities, but this is something that I advise all of my clients. And I say that, you know, if you are laying employees off or, you know, doing anything at all, rehiring on different terms with, you know, salary variances, make sure that it is based on seniority system or some metric that has nothing to do with, you know, gender, age, or any other protected categories. And the same thing goes here. I think it's very important to look at the seniority system that you've got in place. Make sure that that any distinctions that you have in wage are based on merit alone and no other protected categories. And, you know, you need to have a system that measures earnings by quality, quantity, or production, including, you know, things like commissions and bonuses that you may have in place. And as long as you have a justification that's well documented, that is a differential based on other factors that I've just named other than sex or gender, then you should be, you know, on safer ground. So the next slide, which is stuck, the next source of this protection is the Title VII of the Civil Rights Act of 1964. And as you probably know, that protection is much broader, and it includes race, color, religion, and national origin. That's, you know, what we've got in place now. And it contemplates the same 4 justifications, but the burden is much lighter on the employer. And other differences include the early and prior filing requirement with the EEOC, which I know some of you may be subject to at this point. There's additional federal law relating to gender and race discrimination. Essentially, we've got the EEOC and the EEO-1 reporting. And I know that those companies that have already been subject to the reporting are really familiar with what they have to do. And so this shouldn't be that much different, but at the same time, I think it's helpful for you to understand the distinctions. The EEOC has instituted EEO-1 reporting that's designed to collect workforce gender and race ethnicity data from employers. This is the type of data that's, you know, frequently used whenever there is a, you know, litigation involving, you know, gender discrimination that involves wage and hour, you know, Equal Pay Act issues. And what ends up happening is that that litigation necessarily pulls in all the reporting that the company has done over the years. And they look at that data and they determine whether there are, you know, fundamental inequities in the pay. And that's how essentially that case gets decided. You know, in addition to other facts, I think the reporting plays a key factor in determining whether there's a, you know, a pattern of discrimination in that company. And so, you know, that reporting requirement was instituted under the Obama administration. It was halted under the Trump administration, and there was some litigation initiated by the National Women's Law Center. And with the Biden administration, you know, the component 2 may be reinstated. So, we've got to keep our eyes peeled. There's also what I think is really noteworthy is the state trends in pay equity laws. And I think that California has been a leader in some of these trends. California is the first to require this pay data reporting, good for us, bad for us, whatever it may be, right? So, but the bottom line is that we're seeing an increased emphasis on pay transparency. So that's something that you should definitely be looking at. And one of the things that we've already seen in the last couple of years is that, there's been a nationwide, I'm sorry, that's not correct. Across the nation, there's been a lot of states that have banned salary history. So when an employee applies for a job, especially in California, you can no longer require that they provide their prior salary. So that's something that's protected. So what we want to go into is understand who is affected by the new SB 973. As the act basically states, it's private employers with 100 or more employees. So private versus public. So if you're a public company, it doesn't apply to you. And it's somebody who's already required to file an annual EEO-1 report, and you have at least one employee in California. So you have 100 or more employees nationwide, or outside of that, and you have at least one employee in California. And the way that this slide is stuck. The way that we count it is, there are two ways to determine the report threshold. One is that you have 100 or more employees in any given period, in other words, in a snapshot, or you regularly employ 100 or more employees during the reporting year. And if you have less than 100 employees, but you are part of a single enterprise, in other words, there are companies that are affiliated with you with the central ownership, or you're part of that central, company, then you may be considered to have that many employees. And you want to count all your employees, and that's including your temps. And if you have any questions, take a look at the DFEH frequently asked questions. I think that it's actually a fairly good compilation of questions, so you might have your question answered. The deadline here for reporting it's annual, but coming up for us March 31st, and then annually thereafter. And the reporting is modeled, I kind of already said it, but it's really modeled after the EO1 component 2 reporting. It requires categories like gender, race, ethnicity, pay, and hours. And we'll go into that in just a little bit. So the bottom line is that you can satisfy this SB 973 obligation by submitting an EEO component 2 report to the DFEH. And as long as it covers all these areas that, that are required by SB 973, you'll actually be fine. So it isn't going to be that significant of a difference for you if you're already submitting EEO-1 component 2 report. So what we want to look at is how will you be affected, and what you want to look at is, you'll have a significant compliance obligation to track, and you want to, you'll need to report pay, demographic, and hours worked data. And while the full extent of the enforcement has yet to be determined, the law expressly aims to receive, investigate, conciliate, mediate, and prosecute complaints. And again, I think that you want to keep an eye on the fact that this treads back way to, the inequality that has been prevalent over the years. So I think it's probably easier to look at it that way, as opposed to looking at it as a new, I don't know, like tax return, right? So this has a lot of meaning to the country as a whole. So I think that it's definitely a significant piece of legislation that isn't to be ignored. Again, I think that, if you're an employer with at least one California employee and you have, 100 employees and you meet that threshold, don't ignore it. You must report it. I threw in here that if you have multiple establishments, you must submit a report for all establishments in one single report, which is different from, previously you were required to report for each establishment. So I guess that's a little easier. For those companies that have remote workers, you are required to include those employees on the report. There is a question that a lot of my clients are asking, which is, what about confidentiality? What level do we get? And I think that, the bottom line is, regardless of confidentiality, I think that there is a level of it that will be achieved. However, a former employee that's alleging pay discrimination can seek a copy of the annual report from their employer. And if it's not produced in the regular course, it'll be produced pursuant to a subpoena. And I think that what you need to keep in mind is that the premise of this whole legislation is that public disclosure by DFEH of this data, and I think that it is intended to make employers comply with California's Fair Pay Act. And that is, it's kind of a really subtle movement of its own. I don't know if you guys are familiar with the California's Fair Pay Act that became effective in 2016. I don't think that many employers are familiar with it. And so I think that, echoing the language of this legislation, the DFEH maintains that mandatory reporting of this type of data will help trigger compliance. I think this may be something that was, deliberately implemented to really jumpstart compliance in that area. So you really need to keep an eye on, making sure that you're complying. And in terms of enforcement, the annual paid data reporting is implemented by the DFEH and enforced. The DFEH may seek an order to compel an employer to comply. And, this may come up in a situation where an employee, for example, files a complaint of discrimination with the DFEH and alleges something like, the DFEH is really employee friendly. All they have to do is go online, fill out a report of discrimination and throw in something like, there's a practice and pattern of discrimination, wage inequality and things like that. And the DFEH may actually seek an order, to look at your records and to compel you to comply. And you may be entitled to costs associated with seeking, the DFEH may be entitled to costs associated with seeking the order for compliance. So you got to be careful, just like with everything else in California lately, right? Yeah. There is a lot of guidance. I know there's a lot of confusion. So if you go to this link, and this PowerPoint will be available to you after the presentation. So you can go there. There's a lot of good guidance that the DFEH provides. And I also threw in here in terms of the reporting format, if it does apply to you. I think it really aligns with the current requirement, with the current reporting requirement. So I think that it isn't going to be, there's not going to be a stark difference between the two. So that's good news. And I threw in here, in case you're curious, in terms of the nuts and bolts, the report must include the number of employees by gender, race, ethnicity for each of the following 10 job categories: executive, senior level, first, mid-level officials, managers, professionals, technicians, sales workers, administrative report workers, craft operatives, laborers and helpers, and service workers. So you're going to have to, provide the data for these job categories. And it's the same as the listing that you had to provide for the EO1 component reporting. And in terms of the time frame, it's the prior calendar year is the reporting year. So the reporting identifies employee count based on a snapshot pay period of the employer's choice between October 1st and December 31st of the reporting year. But I'm sure that whoever you may be using already for consulting on these issues will help you out through this, reporting requirement. And you're going to have to report the hours. The annual the annual pay data reporting requires that you provide the total number of hours worked by each employee counted in each pay band during the reporting year. So unlike the component 2, these are total hours worked plus all paid time off for all employees of a given gender, race, ethnicity, job category, salary range, and establishment. And I know this is really hyper technical, but again, I'll go into it in just a little bit in terms of what I recommend, how to handle this requirement, given that we are, February 26th, we're about a month away from compliance. For the hour calculations for your non-exempt versus exempt employees, you're going to have to use timesheets or other records to calculate the actual hours worked, plus
What?
any form of paid time off.
What?
What's that? Is someone asking a question?
No.
We'll take all questions at the end.
Yeah. They'll put them in the chat and then we'll.
Okay, perfect. So there's going to be hours calculations that's part of the reporting requirement. And I've laid out here what the requirement is for calculating the hours in terms of non-exempt versus exempt employees. And again, I think that this diverges from component 2 in that DFEH requires the inclusion of time during which the employee was on any form of paid time off or which the employee was paid by the employer. You're going to have to report earnings, and in identifying total earnings for an employee, this is the amount shown on W-2 form. And the result should show for each job classification and establishment the number of employees in each pay band, gender, and race/ethnicity. And, I think that this is such a complex area that I really do encourage you to consult with someone who can help, come in and assess the pay differences, requiring explanations, and see if you've got any of the factors that could be used as justification for the explanation for any, pay inequities. And so, you definitely want to run the numbers to determine, whether and to what extent there are pay gaps and pay disparities. And I do know that given that we're in COVID-19, there have been a lot of legitimate business factors, and you definitely want to speak with someone who can help you figure out what are the legitimate business factors. A lot of my clients have laid off employees seemingly based on factors other than, legitimate business factors. So you want to have your report be looked at, by someone who knows what they're doing. And essentially you'll need to have someone do an audit for you. So if you need someone like that, contact me. I don't do the audits, but I'm happy to put you in touch with someone who can help you. And that's all that I have for now. If there are any questions, I'm happy to take them.
Kristina, is this time period for like all of 2020, but they have to file it by March 31st, correct?
Exactly. Yeah, that's
And
for the prior year. That's
and
the
then
year.
They may not have 100 people employed today, but over the course of the year, if they had 100 people, does this apply to them?
Yes, it would.
Okay, so because I know someone asked me that yesterday, that couldn't be here. So they don't currently have to have 100 people, but if over in the 1 year period of 2020, they had 100 people, then they have to apply, report.
Yes, absolutely.
Yeah, that was someone else's concern that couldn't be here. Well, there's actually no questions in the queue.
It's a really complex topic that I think people are really stumped by, but again, I do recommend, and I know a lot of companies who do this type of analysis, audits, and reporting. So if you need help, reach out and I'll put you in touch with someone.
And one of the concerns of the chamber, why, while this is, like we said, for 100 businesses with 100 or more employees, as we just learned, that's not necessarily how many you currently employ, but over the course of the year. Our concern is, I shouldn't say concern, but why we open this up to everyone is because these things change in California. At some point, they may change it to 50 or more employees,
For
or
sure.
30 or more employees. And
Absolutely.
the data itself, the reporting isn't going to change, just the number of employees that are going to be required to meet the regulation. We do have a question. If you do not, hold on a second. If you do not keep time records for exempt employees per FLSA, can you just show 2,080 hours, which is full time?
I think that should be fine, but that is definitely a question to someone who can review the hyper technical issues. I myself don't specialize in the reporting, and so I'm happy, to put you in touch with someone who can help you figure out how to report that.
Right.
Because there are going to be exceptions to that rule.
Okay. Yeah, because that's a good full-time question.
Yeah. And one thing that I did want to point out is that I know that the application is to private employees, private employers. And I know that a lot of my nonprofit clients have reached out and asked, well, do we, does this apply to us? And the answer is yes, it does, if you are a privately held nonprofit. Even if you're right, unless you're publicly held.
Well, and nonprofits aren't generally publicly held. If you're a private, because nonprofit is your tax status. We're still businesses.
Right. Exactly.
So that, yeah, if you're a business that isn't publicly held, which means like trading stocks and everything,
right,
then you fall into having to do the data pay reporting if you've had 100 employees during 2020.
And you already do the EO reporting, correct?
Any other questions? Because we could give you back a half hour of your day. And Kristina is always available for questions later on. And as she mentioned, she could put you in touch with the people that can help you examine the nuances of the data reporting.
Exactly. And it's coming up soon. So if you fall into the category of someone who has to comply, reach out now rather than later. And believe me, it's worth it to invest into someone who will help you figure this out.
Okay, well, we don't have any other questions. So we thank everyone for being here today.